Get started. Hello, welcome to everyone. Thank you to our panelists for joining us today, and for everyone in the audience, our attendees, for coming to listen. This panel is part of our Terrorism and Social Media stream at our week of events at the Legal Innovation Lab at Swansea University. And in this stream, we're going to focus, our focus moves now onto topics related to responses to terrorist use of the internet. And the topic of this panel is content moderation, transparency reporting, and human rights. And we have panelists from a range of great organisations engaged in important work on critical issues in this area. So I'll briefly introduce each of our speakers. First, a little bit of housekeeping. So each of our speakers will speak for about 10-15 minutes, and then there'll be an opportunity to ask questions once the presentations are finished, and you can type your questions into the Q&A box, and I'll pick them up and make every effort to ensure everyone's questions are answered. Okay, so on to our speakers. Pleased to welcome today Jeremy West, a senior policy analyst at the OECD. At the OECD, Jeremy leads research teams working on digital economy policy issues. And he's going to talk to us today about the OECD's work on developing a voluntary transparency reporting framework for terrorist and violent extremist content online. Then we have Maygane Janin. Maygane is a senior research analyst at Tech Against Terrorism and leads the mentorship program there with smaller companies. So today Maygane's going to talk to us about the support for smaller platforms in developing their transparency reports. Last but not least, we have Gabrielle Guillemin. Gabrielle is a senior legal officer at the Law and Policy Team, Article 19. She leads Article 19's work on internet policy and digital rights policy issues. And Gabrielle's going to talk to us today about transparency reporting issues that arise in the context of her work with the Christchurch Call Advisory Network and GIFCT. So that's enough from me. I'm going to pass to our first speaker. So over to you, Jeremy.
Thank you very much, Katy. It's a pleasure to be here. Let me just start by sharing my slides. Hopefully you all can see the first slide now. So I'm going to be speaking to you today about the OECD's voluntary transparency reporting framework for terrorist and violent extremist content online, or TVEC. In case you're not familiar with the OECD, I'll just say a quick word about it. It is an international organization that provides policy analysis and recommendations to governments on a range of economic and social issues, including taxation, competition law and policy, international trade, and internet governance, among many other things. We have about 3,000 employees, including many economists, statisticians, and lawyers. So with that out of the way, let me go to the first substantive slide, which is about the origins of this work that we're doing around transparency and TVEC. So 2019 was a pivotal year, and probably the most pivotal event for this work that year was were the attacks in Christchurch in March of that year, which of course led to the Christchurch call. But then other terrorist and violent extremist attacks that occurred that year kind of kept momentum going, so to speak, and generated quite a bit of interest among policymakers, and led to other statements from groups like the G20 and the G7 calling, like the Christchurch call did, among other things, for greater transparency from online service providers around the TVEC that was showing up on their services and the actions that they were taking to counter it. So these international calls, combined with the tragic effects of TVEC online in the physical world, as well as the regulatory wave that has started to form in response to this, all of those things combined to lead us to undertake this work on developing the VTRF. So when we started off, the first thing that we did was to check the current state of transparency reporting among the global top 50 online content sharing services, which is a deliberately chosen term to reflect that it's more than just social media. In fact, it's more than just online platforms. So we wanted to include other things. And what we found was that many of the top 50 do indeed have policies against the use of their service for TVEC-related purposes. And I'm using TVEC as a shorthand. We know that companies don't all use that acronym, but I'm referring to terrorist and/or violent extremist content. So we found that they do have policies, but we also found that as of last summer, when this report came out, only 5 of the top 50 were issuing transparency reports that were specifically about terrorist or violent extremist content. And even among those 5, the reports were all different. They defined the terms differently. They were reporting different metrics, and they were reporting them with different frequencies. So the result of all this was that it's very difficult to get a broad cross-platform perspective on industry efforts to counter this kind of content, how well they're working, and even what the effects on human rights are. So if we fast forward to now, we're just putting the final touches on the second edition of this report, and there is some good news, which is that the number of top 50 services that do this kind of reporting has jumped from 5 to 11. Granted, some of the newer reports are perhaps a bit basic or simpler compared to the ones that are out there, but it's okay. It's the first time that many of them are doing it, and the good news is that the number is increasing. That this kind of reporting is becoming more common. Now, at the same time, our research showed a parallel or similar problem on the government side, which is that there are a number of jurisdictions that either have or are considering enacting regulations in this area that would or could require transparency reporting around TVEC. And these regulations too, perhaps not surprisingly, are not coordinated. So they are calling for different kinds of information in the reports and different metrics and on different timetables. So what that means is that for platforms that operate in many jurisdictions, as quite a few of them do, they may go from not having to issue these kinds of reports at all to suddenly having to issue many versions of them every reporting period. And making matters worse, the countries will be replicating all the costs of developing and updating the reporting requirements, setting up and maintaining filing infrastructures to handle the reports, managing those again and again across all of the countries that are issuing these kinds of regulations. So to sum up, I put the problems on the left and what we're proposing to do about it on the right. Basically, there's not enough of this kind of reporting. What there is isn't comparable enough for a cross platform or cross-service perspective, there is this risk, growing risk of regulatory fragmentation and the implications for a greater compliance burden on firms. And there's this issue of the duplication or replication, really, of public costs. So how can we solve these problems? The OECD is not a business. We're an international organization. But our idea is inspired by a business model that has been very successful over the past 20 years or so. In brief, our idea is that the OECD itself will become a multi-sided online platform with all the efficiencies and network effects that come along with that, or at least potentially. We want to provide a central service that facilitates transparency interactions between governments and online content sharing businesses as well as the public. So to do this, we're developing a transparency reporting framework for terrorist and violent extremist content based on an international multi-stakeholder consensus that's informed by a deep consultation with experts from government, business, civil society, and academia across a range of disciplines. The framework will include a standardized reporting template that we're trying to design so that any company can use and that every OECD jurisdiction will support, or we hope they will support when the decision time for that comes. In fact, we hope that jurisdictions outside the OECD membership will also decide to use this framework. So then, by providing a web portal where the standardized template can be accessed and completed, the OECD will provide what we hope is a convenient hub where companies can fill out a single transparency reporting template that simultaneously satisfies multiple jurisdictions at once, instead of having to file these things in different versions multiple times every reporting period. At the same time, the web portal will also provide a convenient service to governments and the public, because the completed templates will go into a database that we will secure and maintain, just as we do with many other kinds of databases at the OECD. So the reported information will be there, available for anyone to access, visualize, and use. So before I sign off, I just want to take a short few minutes to acknowledge that we understand that this is not easy for companies. It's not easy for them to do the transparency reporting, and it's not easy for them to address this kind of content in the first place. And for a number of reasons, one of which is that there's just a whole lot of it. And we put together this table comparing what it's like for a micro platform and one of the biggest platforms. So Facebook's on the right, and just quickly, you can see the statistics. They've got a whole lot of users, comparatively a large number of employees, and a whole lot of terrorist content that they actioned. This is for the first half of 2020. It works out to about 100,000 individual pieces of terrorist content per day. And on an employee per employee basis, it's 1.7, but of course, not all the Facebook employees, not even close, are working on this. Still, 18 million, more than, that is a lot for half a year. And this is just terrorist content. They also have to deal with violent extremist content and mis and disinformation and spam and violent imagery and all the other kinds of things that they have to worry about. So then there's the micro platform in the middle column, which has just one employee. They get in a similar time period, they got about 900 pieces of content to deal with, but it's just one guy. So for him, it's 5 pieces of this content to deal with a day, and there's only one of him, and he has to do everything else for running that platform. So it's a challenge in both cases, and we get that. Another major challenge is that there's no perfect way to detect and moderate this content. I won't go through all these different methods, but just quickly focusing on the internal methods, for example, they all have they both have pros and cons. You know, humans, if they're well trained, can be very accurate, but they're slower and they cost more on a marginal basis. Automated systems are much cheaper marginally, on a marginal cost basis, I mean, and they're super fast, but they're subject to bias. And they can miss things or be too inclusive. So it's hard to tune them just to the right settings. And then lastly, to do this, you have to navigate a whole lot of gray areas. And I don't think there's time for me to get into this too much, but there's just some illustrations here of the kinds of considerations. It's not just a simple matter of finding all the pictures of people getting their heads cut off or something like that. It's much more nuanced and difficult than that, and we get it. What this adds up to is really, this is the wild frontier of digital economy policy. I mean, we deal with a lot of this, the broader issues in digital economy policy. This one's at the frontier. It's super hard because neither companies nor governments are entirely certain about what they should be doing or the best way to do it. The best practices just aren't there yet. So that's what the OECD is for. I mean, we're an evidence-driven organization, and what we're trying to do in this project is to improve the evidence base so that policymakers can approach this in an informed and calm and rational way, instead of reacting all of a sudden to the latest terrible tragedy. So let me stop there and give everybody else a chance. I want to thank you very much for your attention.
Thank you, Jeremy. That was really interesting. I think if we pass straight to Maygane, which should follow on nicely, talking about the work with smaller platforms in particular.
Thank you, Katy. And on behalf of Tech Against Terrorism, I just want to say thank you to the World Track team and Swansea University for inviting us today. And especially for this panel, because this is exactly what my day-to-day job is. So hi everyone, I'm Maygane. I'm a senior research analyst at Tech Against Terrorism, and I lead on the mentorship and membership programs, which are designed to help smaller tech companies with improving their counterterrorism and content moderation approach. And transparency and human rights are key to everything that we do in this regard at Tech Against Terrorism. I'm going to talk a bit more about this in a minute, but just before, a little reminder about who we are at Tech Against Terrorism. We are a public-private partnership, and our core mission is to support the tech sector in countering terrorist use of the internet whilst safeguarding human rights and freedom of expression online. We mostly focus on smaller and medium-sized platforms. As Jeremy said, it's extremely complicated for such platforms to counter the terrorist threat and to produce transparency report related to that. So we're here to provide all the policy and practical support that they need to build up a counter-terrorism approach. To do so, we work with a broad range of stakeholders, including government and intergovernmental organizations, Public Safety Canada, notably funded Orthodox Content Analytics Platform, and UNCTAD is one of our core partners. We also work with industry-led initiatives. So the Global Internet Forum to Counter Terrorism, GCT, is our key partner for everything knowledge sharing. And we work with civil society, academia, and other counter-speech organizations as well to constantly build up our understanding and knowledge of terrorist use of the internet so that we can then feed that back into the support that we provide to smaller tech companies. Our work at Tech Against Risk is divided around 3 key pillars. So in terms of analysis of the threat and outreach, we have our own open source intelligence team, and they not happily help us identify which platforms are the most exploited or are the most at risk of future exploitation based on user migration and trends in terrorist use of the internet. Our second work stream is on sharing and best practice, but where most of my work at Tech Against Terrorism is actually, I'll talk about the mentorship and membership program a bit more in a minute. We also host webinars, and we used to have global workshop. Hopefully those will be back sooner than later. And we also provide training materials. On that, we'll be relaunching our knowledge sharing platforms in a couple of weeks, so stay tuned for that launch. The KSP is basically this online hub with all the resources that tech companies might need to understand terrorist use of the internet and how to best respond to it in line with human rights standards. It includes various resources, including list of terrorist and non-extremist symbols, designation list, our key general recommendation, whether that be for transparency reporting or general content standards. In terms of tech development, our key support product is a terrorist content analytics platform, the TCAP, which alerts tech companies when we locate branded terrorist content from designated terrorist organizations on their services. This is to help with content classification and moderation at scale and in the long term. We have really great statistics on that. This has led to really great results. So I'll invite you to follow TCAP alerts on Twitter to have all the latest statistics every Friday. Now a bit more into the actual support that we provide with counterterrorism and content moderation. So as I said, a lot of this goes through our mentorship and membership programs. So the mentorship program first, it's meant as an initial support program to help tech company assess and improve on their content terrorism and violent extremist policy, as well as content moderation in general, all in line with the highest human rights standards. This is also meant as a path towards dual membership. So this is really designed to help tech company meet not only tech against terrorist requirements for membership, but also membership requirements for the GiveCity. So every platform that is accepted as a GiveCity member has received tech against terrorist support prior to becoming a member for the GiveCity. To ensure that tech companies are not left unsupported once we have completed the mentorship, we also have the membership program. That is really meant to provide continuous and long-term support to all tech companies. We work to build trusted relationship to really understand how a tech company works, what different kind of services they provide, the size and capacity that they have with them, to be able to support them in strengthening and future-proofing the policy, their enforcement mechanisms, but also their understanding of the threat. And all of our recommendations are not only based on the threat itself and its evolution, but also on the changing online regulatory landscape, so that we can help tech companies adapt their system to changing regulation over time. In practice, this is focused around 3 key pillars. The first one is about content standard and respect for rights. Every tech company will receive an in-depth policy review when we start a mentorship program for them. And based on that, we'll be able to draw bespoke recommendations for those platforms, depending on the different services they have, the user base that they have. A younger user base platform will not receive this exact same recommendation as a platform with an older user base. It also depends on the jurisdiction they are in. As I said, we keep track of all online regulation to be able to tailor a recommendation for them. We also make sure that all of our policy support is actually practical support as well, and we provide guidance for tech companies on how to practically implement the policy and enforcement mechanisms and how to operationalize the definition of violent extremism and terrorism. We also help platform with terrorist content identification and takedown, notably via the TCAP, but also with regular OSINT briefs that are sent to members and mentees. Those briefs are bespoke to each platform and are really meant to help smaller and medium platforms that don't necessarily have the capacity or the resources to be able to conduct at scale proactive monitoring of the services and help them comprehend better, have a better comprehension of the threats on the platform. This also helps us to identify potential content circumvention techniques used by terrorists and violent extremists or pre-existing loophole in the content moderation system, so that we can draw a recommendation for them to adapt their content moderation system to the threat and fix different loopholes. Then we have a world pillar that is dedicated to transparency reporting. I'll get into that in just a minute. All of the work that we do for supporting the tech sector is underpinned by our 4 guiding principles: human rights and freedom of expression, rule of law, transparency and accountability, and tech platform autonomy. Given today's topic, I'm going to focus on the first one and the third one. I just really want to stress the importance of tech platform autonomy. As I said, we work to build trusted relationship, and we found that this worked really well, especially with smaller platforms or platforms that don't really understand the threat at first. The fact that we develop this relationship over time, that we make the effort to actually understand the capacity they have and the threat on the platform, really help them change their approach to content moderation and counter-terrorism. So we really work hard to provide bespoke support to all of our different mentees. Now, in terms of human rights, we've developed the Tech Against Terrorism pledge, which we ask all of our mentees to sign as part of the mentorship process. The pledge is a set of 6 guiding principles that platforms are meant to follow when we're conducting content moderation and content terrorism on the platform in order to safeguard human rights and especially freedom of expression online. So far, 19 platforms have already signed the pledge, and I believe we have 2 or 3 more platforms signing it this month. Otherwise, human rights commitment is really at the core of what we do. It's literally, statement mission, and it's constantly in the back of our mind when we're providing support to tech companies. So it's a core priority around Protect Against Terrorism membership, as well as for GFCT membership. And every time we conduct policy review, or every time we assess the platform content moderation enforcement mechanism or withdraw recommendation, human rights is constantly there, and we try to help platform give a greater attention to the potential impact of content moderation on human rights and freedom of expression. We can also help platform with dedicated human rights assessment to better understand exactly what their content moderation, how their content moderation can be impacting human rights at the moment. Our knowledge sharing platform also includes resources that are dedicated to human rights, including our key recommendation, as well as a human rights standards table, which summarizes all the highest international human rights standards that can be applicable for content moderation or tech platforms in general. Now, in terms of transparency and accountability, since we started the mentorship in 2018, this has really grown into being a pillar of a mentorship and any support that we provide to smaller tech companies. We've helped many tech companies with transparency reporting. Jeremy just mentioned Just Paste It. We've actually helped them with processing their first transparency reporting. More recently, we've helped Ask FM as well. So we provide policy support to tech companies in understanding what they're doing well and what we can improve in terms of transparency and accountability toward the user in general, not just focusing on transparency reports, but also in terms of practical support or transparency reports, we can help a tech company that lacks the resources or sometimes just the understanding of what a transparency report even is. So if a small or medium-sized tech company comes to us tomorrow, we can help them understand and develop the different content moderation policies and processes that they need to underpin the transparency report, what kind of support system they need to be able to collect the data, which is usually quite a key challenge for tech companies, as different user reports might not come all in the same form. You have different way of reporting content. It's not all standardized, so we can help platform with standardizing this. And improving on that. We can also help platform with identifying different metrics that can be relevant to their user base and to different services that they provide. And we can also conduct review of transparency report before it's published. Our knowledge sharing platform also includes dedicated resources for transparency reporting, notably our transparency report menu. I really want to insist on the fact that our transparency report menu is by no means meant as a compulsory framework or for tech companies to follow. It's a very long and very extensive list of all the different kind of transparency metrics you can find in transparency reports nowadays. I don't think that even the most extensive transparency report that are currently being published include all the metrics that we have included. It's really for tech companies to understand what a transparency report can be, what all the possible metrics of inclusion can be for transparency reports, and to pick and choose which metrics are relevant to them and they can produce. In addition to that, we'll soon be launching our transparency guideline for reporting on counterterrorism online efforts, not only for tech companies, but also for governments. So as Jeremy mentioned as well, you have more and more discussion from policymakers about mandating transparency report for tech companies. So we really want to inform public discussion and policymaker understanding of what transparency reporting is and what it means for a tech company. This is also meant to help us build, consolidate a framework for tech answers on practical support to the tech sector. So our guidelines for tech companies are really based on a holistic approach to transparency. It's not just the transparency report, it's all the content moderation policy and enforcement mechanisms that you have. They don't all have the same definition of terrorists. When we do have a definition of terrorists, what do we need to build upon that? What kind of moderation enforcement we need to build upon that? What are all the processes? How can we collect data? All of that underpin transparency, we take all of that into account. We also want to recognize platform diversity. Not all platforms have the same purposes, user base, policies, and processes. You don't do a transparency report for an encrypted messaging platform the same way as you do for a user-generated content platform, or as you do for a platform that hosts mostly different kind of chatting servers. These are all different kind of content, behavior that can be hosted. It's different kind of terrorist use of the internet pattern. It's different content moderation strategies and processes. So it's really important to recognize that. And at Tech Against Terrorism, we don't believe that mandating a standardized transparency reporting framework will help in any way increasing meaningful transparency from the tech sector. We really also want to acknowledge the differences in resolution capacities. Transparency reporting is extremely complicated. It's time-consuming, it's resource-consuming, even for the biggest platforms. So we cannot be reasonably expecting smaller platforms to produce the same kinds of detailed metrics and transparency report than the larger and longer established platforms are doing. It's not just a micro-sized platform like just Pasted. Over platform might just be 10 individual, we might be 100 individual, which only have 5 people in the trust and safety team. So it's all complicated. It's different sizes, different capacity. We have to acknowledge that in our guideline for tech companies. In addition to that, we want to call for meaningful transparency from government and law enforcement on their counter-terrorism reports and how they cooperate with tech platforms to do so. So to this day, only the Australian government and the EU Internet Referral Unit produce transparency report, if I'm not mistaken, and we want to encourage government to be more transparent and accountable on their effort to counter terrorist use of the internet. This is not only to allow for civil society oversight over what government and law enforcement are doing to counter terrorist activities, but post-transparency report can also provide extremely valuable insight into how terrorists are using the internet, the different trends, and the evolution of the threat. And on that, I'm arriving at the end of my presentation. I just want to highlight some of the tangible results that the membership and mentorship programs have brought so far. Just to give you an idea, we've had 26 mentees since the start of the mentorship. 10 of them have already completed the mentorship and become Tech Against Terrorism members. And I really wanted to highlight the fact that 4 mentees have already published transparency reports whilst receiving our support via the mentorship program. 1 has updated the metrics that are included in the transparency report, and 11 of the mentees have updated the content standard based on a recommendation. And I think even most importantly, 5 of them have strengthened and changed the way they think about content moderation and counter-terrorism on their platform. And yeah, I hope you found this useful, and I guess back to you, Katy.
That was fascinating. Thank you, Maygane, for sharing that work with us. I think one of the themes is already the importance of the multi-stakeholder approach across both presentations, which I think feeds nicely into what Gabrielle is going to talk to us about. So I'll hand over to Gabrielle.
Hi, thanks very much, and thanks very much for the opportunity to take part in this very timely event. I would like to talk a little bit about the experience of my organization, Article 19, as a stakeholder in these various new fora, namely the Christchurch Core and particularly the Christchurch Core Advisory Network, and the GIVCT, which is the Global Internet Forum on Counter-Terrorism. So I'll briefly talk a little bit about the origin of these initiatives, and then I'll get into some of the issues that arise in relation to transparency reporting. But first, Jeremy has already touched on how the Christchurch Core came about. It was really in the aftermath of the terrible terrorist attacks that took place in Christchurch, New Zealand. And at that point, one of the significant and new feature of this particular attack was that it was being live streamed by the terrorist, clearly with a view to glamorize his despicable acts. And so he was doing so on social media, and obviously governments were very keen for this to stop as soon as possible. One of the key problems that arose subsequently was that there was also some reporting of the terrorist attacks. And so one of the questions that arose was around what should happen to the footage that the terrorists had used, and how should it be, what should be done about media reporting on that particular footage, or whether media reporting might include that particular footage. Another significant aspect of these events was that as governments were keen for this live streaming to stop as soon as possible, they had some difficulty in reaching out to the platforms. At least that's, generally speaking, one of the complaints that were made at the time. And so that led to this joint New Zealand French initiative, where one of the key purposes of it was to develop what was called a content incident protocol. So essentially having a mechanism that would enable action to be taken promptly by the social media platforms that were part of and supporters of the call to deal with these kinds of incidents. And so another remarkable feature of that Crushers Call initiative was to create an advisory network that was also made up of a range of civil society organizations working on digital rights issues, free expression or privacy, amongst others, and most importantly also groups from the minorities that have been particularly targeted during these attacks in New Zealand, so Muslim associations primarily. And so so the work started from that basis. And I think it's important to flag this because in all of these initiatives, a lot of structures have developed, multi-stakeholder fora. But I think it's important to remind ourselves why that these are perhaps not as straightforward as one might think. I think it's, of course, no one wants to see terrorist content, but I think it's important to remember that what is terrorist content is actually something that is hard to define and can be contested. So there is no agreed international definition of terrorism, for instance. Still less of violent extremism, and extremism is really at the far end of the spectrum and really doesn't have, that doesn't really say very much about any kind of ideology per se. It's more of a qualifier. And so, and at least from a human rights law perspective, this is a problem from a legal certainty point of view. Another issue that arises in relation to these definitions that Jeremy has already touched on is that someone's terrorist may well be someone else's freedom fighter. And this plays a role, as we'll see subsequently, in relation to the way in which the platforms themselves approach these kinds of issues. And so I think that's really where the difficulty is for a lot of this work, because transparency is, of course, vital, but there is a lot of discussion around what are the definitions and policies that are being used as part of these various initiatives. What are the terms and conditions that the companies are applying? What are the definitions that the various initiatives are using? And how do they match up also with the legal requirements? Because quite often there's an interesting interaction between all of these. And as I said, as a free speech advocate, the problem often is that terrorist content may well, in the drive to remove it, and because filters are often inaccurate, there may well be problems in relation to the content that is being removed. And for free speech advocates, the removal of content on difficult topics, controversial topics, that really shouldn't be removed. So that's really why I think organizations such as Article 19 are involved in these discussions. So I thought it would be important to remind ourselves of that to begin with. Now, GiveCT started off as a business-led initiative to fight against terrorist content. And following the events at Christchurch, I think there was a drive to really use it as a vehicle to then pursue some of the work, in particular in relation to that content incident protocol. And so GiveCT was set up as a separate entity and structure, some kind of NGO under US law, to deal, address, and prevent the dissemination of illegal terrorist content. And so just much like the Crushers Call Advisory Network, what is striking about it is that these are both multi-stakeholder structures, particularly when it comes to GiveCT, which is an organization in and of itself. And so in both of these, you have like the various players. You have the companies, you have the governments, and you have NGOs and academia taking part, and sometimes in the form of an advisory network for the Christchurch Core. And so I think there's been a lot of questions around what exactly, for example, an advisory network, what is its role, and how this is all supposed to work. But what's been very clear is that because these structures exist more or less outside any recognized traditional multilateral fora, such as the UN, it's been very important for them to gain trust, and that's where transparency comes in. And so I think that's really why, I think that's part of the reason why transparency is so important in this discussion. And it's important because also there's still very little understanding about what's really happening with all of this content online, including terrorist or TVEC type content. And so I think that's really the work that's been happening within these various, both the Christchurch Core and the GIFCT. As part of the Christchurch Core, there's been various work streams that have been created after the 2-year anniversary of the call itself. And one of them is around transparency. And GIFCT, of course, also has a similar work stream. And really both initiatives really work alongside each other and tackle a lot of the same issues. And so these issues are, they've been already very comprehensively covered by Jeremy from the OSCD's perspective, but really it's about understanding what's happening, both in terms of one, the companies. 2, GIFCT has a special feature, which is its hash database. And 3, what governments themselves are doing. And so the challenges are multifold. And here again, I'll just reiterate a lot of the points that Jeremy has made around a lot of the companies defining terrorism very differently. In fact, many of them, for example, Facebook, they use dangerous organizations as a key reference point. And that in itself raises a host of other issues, because there's very little knowledge about what constitutes a dangerous organization under Facebook's terms, community standards. To the extent that Facebook may be using designated terrorist lists, they're not public. So people wouldn't know if these major online platforms are using UN lists. They're probably using US lists because they're US-based companies. But for example, there's very little knowledge about whether or not these companies may be using the list of other countries. For example, Article 19 works a lot on terrorism in Turkey, where the PKK is clearly a designated list, but quite often things are not necessarily as clear-cut as they might seem. And we've also seen in recent years, the Turkish government has cracked down on a lot of journalists that they've branded as terrorists and are investigating or prosecuting for terrorist offenses. So all of these things, all of this, it's really quite impossible to know just by looking at the terms of service and the transparency reports of these companies at the moment. And so really, I think for a lot of free speech advocates, it's really trying to tease out, understand how the companies are operationalizing their own terms of service, what sort of processes they have in place, and really understanding how, if at all, and really encourage them to take into account human rights considerations as they do so. And when it comes to GIFCT, one of the key issues is really understanding how one goes from a company decided that content may be in breach of its terms of service to going into the database. It's still very difficult to understand for a lot of people, and therefore knowing whether or not, if there's a hash in that database, whether it might be content which in another context may well be perfectly lawful, for example, because it's been used for journalistic purposes. And so that in itself then raises a host of other issues about any due process or mechanisms in order to challenge the decisions that are being made about including certain hashes in the database. But again, at the moment, very little transparency around all of these different issues. The third aspect, which also remains very opaque at the moment, is around the role of governments themselves. In an initiative like the Christchurch Core, it was initiated by governments. I think here, like one of the difficulties that arises is really around ensuring that governments make use of the advisory network and do consult with the network in relation to domestic pieces of legislation that work alongside the Christchurch Core itself. And there's, of course, like the work of various work streams, which is going to go forward, but realistically will take some time because these are all initiatives where people put in a lot of time on a sort of voluntary basis, so to speak. When it comes to GIFCT, is really understanding the role of governments in relation to the governance, of the organization, and also the government's own efforts when it comes to transparency, because some of the key issues that arise again are that it's not always clear when the government issues an order that a company can then disclose that information. Gag orders are alive and well, so this is still not known. Governments may also make use of certain internet referral units, and these units may make requests to the companies, but it's still not entirely clear how these are dealt with, how they're dealt separately from legal requests, or what weight is given to any particular special flagger status. And so all of these things, government themselves are not particularly transparent about it. And so it's really trying to figure out how to get more transparency about what is really happening, so that we can have the beginning of an understanding of what's happening, and then ultimately accountability. And so these are, I think, the key issues that arise in this space and these particular initiatives in terms of transparency and human rights. There's many other aspects, I'm sure, like that we could talk about, like some of the, what should be transparent. But I think like Jeremy has already done a stellar job of talking about a lot of the points that arise. So I think I'll just stop here and I'll wait for any questions. Thank you.
That's great. Thank you, Gabrielle. It's really interesting to have that perspective, I suppose, as the stakeholder in the multi-stakeholder initiatives, which are key, but as you highlight, don't come without their challenges. And it's important that each initiative and structure is complementing each other. And as you state, that the governments use and consult the initiatives, the advisory boards, to make them effective. Okay, so we do have some questions that have come in as you were all speaking. So the first question, it was predominantly aimed at Jeremy, but I think I'll throw it out to everyone because it's important. So how do we ensure platforms are motivated for transparency reporting? So particularly if you're talking about in the absence of legal requirements, what can we do about incentives for participation?
Shall I take this first, Katy?
Yes, sorry, yes, you go first.
Okay, so since it was aimed at the OECD or me, we are a soft law kind of organization. We don't have regulatory authority, as you probably know. I think the questioner was Gillian, so thanks very much for the question. What that means, being a soft law type organization or a soft power type organization, is that we promulgate standards and best practices, and over time they get adopted. And then this kind of soft peer pressure starts to form. And other entities find themselves being expected to use those standards and best practices also. This, in our world, this usually applies to countries. When one country starts doing something and then more and more start doing it, then they all start looking at the ones in the room who aren't doing it. And there's this kind of awkward pressure for them that develops until they start getting their act together and following the best practices. But the same kind of thing can apply to companies or work equally well with them. So as some of the companies start to use the voluntary transparency reporting framework and are recognized as having provided transparency information that meets the OECD standard, that status may start to become something that's sought after, that's desirable. And then this soft pressure to achieve that starts to build on other companies as well.
Thanks, Jeremy. I wondered, Maygane, if you had, or Gabrielle, sorry, you've got your, did you want to add something there?
Yes, just very quickly picking up on Jeremy's point, I think it's also important to see, understand like self-regulatory measures as a precursor to sometimes actual regulation. And so I think there is a strong incentive for companies in general to be ahead of the game, because then they can shape what happens a lot more. And by having already something in place, that's much more likely to then become the standard for others. So I think that's why we often see companies being keen to be ahead and thinking about these issues, because then that can also help both interact and or shape if regulation becomes inevitable, that really enables that to you know, it really influences what you get to see then in the law. So I think in that sense, self-regulation is a very useful tool. I mean, obviously I don't work for a company, but I think it's a very useful tool for them from that perspective.
To follow up on that, I completely agree with Gabrielle. Self-regulation is extremely important. And when you take a look, not just at provision that would mandate transparency reporting in online regulation, but also provision that mandate in clear content standards for user, which will be the case with the video sharing platform regulation in the UK, but also even with the guidelines in India. Most of the things are things that platforms already do, or where they need more support in order to be able to be more transparent. So self-regulation is really important. And in terms of voluntary framework, it's not just whether a platform is willing to do transparency. In our experience working with different kind of platforms, the mentorship and membership programs, all platforms are willing to do better. They're willing to tackle terrorist content. They're willing to be more transparent. And the issue usually is not their willingness, it's the capacity and resources. That's why we focus so much on providing practical support for tech companies at Tech Against Terrorism.
That's great. I said that kind of leads on to another question that's come in. So Maygane, you spoke a lot about the support Tech Against Terrorism gives smaller platforms. There's a question here about what support the OECD will provide to platforms so they can comply with the reporting template where they lack capacity, and whether you're working with, would work with, or are working with organisations like Tech Against Terrorism to help with this issue.
Yeah, thanks for the question. So Tech Against Terrorism has been part of that consultative body of experts that we've been working with on developing the framework since the beginning, and have provided valuable perspectives on what, especially what small platforms can and cannot do. As far as the OECD funding, we're usually the organization that receives the funding. We're not the organization that provides the funding. So we have our hands full just funding our own research and analysis. But what should happen is that if OECD members like the voluntary transparency reporting framework and they want companies to use it, which they do, including small and medium enterprises, then the argument that organizations like Tech Against Terrorism, who exist in part precisely to help those kinds of companies to do transparency reporting, that argument becomes stronger. So we can say to our members, this is great, you love the VTRF, super. If you really want to see uptake, why don't you think about increasing funding for, say, Tech Against Terrorism and some other organizations that might be able to help as well.
Okay, thank you, Jeremy. There's a question here. Have companies or any global initiatives sought collaboration with regional intergovernmental bodies, such as African Union or other regional bodies, on content monitoring and control, so content moderation? Not sure if anyone had any thoughts on that question.
I can provide a quick answer, just to say that Tech Against Terrorism is looking to help this dialogue between international and regional organizations and tech companies. We are conducting a series of webinars in collaboration with UNCTAD, which will bring together different regional organizations to explain what they can do to help tech companies. We already had one focus on UN bodies last December, and we're going to have the next one probably focus on organization in Southeast Asia this August.
Thank you, Maygane. We had a question. I wondered, maybe Gabrielle, if you could talk. It was about the problem of content removal, so where the content's deleted, and I didn't know if you wanted to expand a bit more on that. You touched upon it when you were talking about some of the challenges, the wrong type of content being removed. If you just wanted to expand on that.
Well, there's two ways in which content can be removed. It can be removed under a company's terms of service, or it can be legally mandated. When it's legally mandated, it's usually because either a law enforcement or a court has served an order on the company. And so these are the different ways in which it can happen. I think one of the difficulties is that sometimes, I think particularly for law enforcement, it can be more convenient to effectively flag content to the companies so that the companies are not legally obliged to remove it, but they'll consider it. Usually, law enforcement may well have like a special flagger status, which means it will be examined more quickly. Probably create some kind of presumption that it's probably indeed terrorist content, except that it hasn't been said by a court, which is a problem from a free speech perspective. But the fact that it has to be removed on the terms of service is problematic from a free speech perspective and rule of law perspective, because quite often the terms of service are more expensive than the law. So more content can be removed under terms of service, to put it simply. And so, it's probably more straightforward from both in terms of the content itself and in terms of procedure to seek a removal, albeit on a voluntary basis, via a company's terms of service. And that's also why it's very important when it comes to transparency to be able to track changes to the terms of service, because quite obviously, the numbers, and that's often how it's done, the numbers will change, because if you change your definition, there'll be more content that will be removed, your numbers will go up. So I think it's important to bear that in mind, is that there's a correlation between the policies and definitions and how broad or narrow they are with the amount that gets removed.
Okay, thank you for answering that. So we are almost out of time. One last quick question. It's been answered in the chat, thank you. Okay, so I would just like to thank everyone, all our attendees, for joining us and listening to the discussion, but particularly to our 3 panelists for some fantastic presentations and really interesting insights to all your work in this area. And there's lots more to be done. So yeah, I will end the presentation now. Thank you again all for coming, and we hope to see you at some more of our panels throughout the week. There's one this evening which follows on nicely from this topic. Okay, thank you everyone.
Thank you.
Thank you. Bye.
Thanks. Bye-bye.